The House will please come to order. We thank our Senate colleagues for visiting with us this morning. Welcome, members, to the 30th day of the 66th Wyoming Legislature, Wednesday, March 31st. And I don't keep track of every day, but yesterday 1,000 people viewed our day session. Now, some of them may have been watching at midnight last night on the replay, but 1,000 people. That was an interesting note this morning. Please call the roll.
Convening roll for the 30th day, Wednesday, March 31st, 2021. Andrew. Baker. Banks. Bear. Blackburn. Brown. Burkhart. Burt. Clausen. Clifford. Connolly. Prego. Duncan. Eklund. Air. Flittner. Fortner.
Here.
Gray. Greer. Hellenan. Haroldson. Harshman. Heiner. Henderson. Hunt. Jennings. Kenner. Knapp. Larson Lloyd. Larson Dan. McGuire. Martinez. Nyman. Newsom. Nicholas. Oakley. Obermueller. O'Hearn. Olson. Ottman. Paxton. Provenza. Roscoe. Schwartz. Sherwood. Simpson. Summers. Stith. Stivar. Sweeney. Walters. Washut. Western. Wharf. Williams. Wilson. Winter. Yin. Zwanitzer. Mr. Speaker. Jennings. Hunt. Winter. Harshman. Martinez. Sweeney. Worf. $56 present, 4 excused.
Thank you very much. So members, we still have a Senate committee meeting, and so a couple of our members I know are presenting in that Senate committee. So members, if you would join Pastor Zach from Grace United Methodist Church.
Good morning. I invite you as we go into a time of prayer to take in a deep breath and let it out. If you'll pray with me. Gracious and loving God, we come in these moments to be here, to be with each other. May we remember the fullness of your creation, both people and the land that we live and serve in. calm our hearts, calm our minds, guide our conversations. As we take that breath in and out, may it be full of peace and grace this day. We pray these things in your name. Amen.
Thank you, Pastor Zach. And I don't know if you folks noticed, but every day Pastor Zach has a little different color shoe on. Pretty stylish, pretty stylish. No, you can't start doing that in the body. There's certain decorum. All right, so there was a privilege of the floor. Where is Representative? Oh, actually, Journal Committee report, then we'll do the privilege.
Your Journal Committee reports that the Journal of March 30th, 2021 has been read and recommends that it be approved. Representatives Haroldson and Provenza.
Thank you very much. Representative Clifford. Privilege of the floor, please proceed.
Thank you, Mr. Speaker. Today I have the honor to introduce a 2008 and fellow Northern Arapaho tribal member, Mr. Jordan Dresser, who graduated with a bachelor's degree in journalism, has worked as a reporter for the Denver Post, Salt Lake Tribune, and the Lincoln Journal-Star. He worked as the public relations officer for the Wind River Hotel and Casino, and for 8 years before moving on to the tribe's preservation office as their collection manager. He's also a filmmaker with the films What Was Ours and The Art of Home, and he will make his directorial debut with an upcoming film highlighting the missing, murdered Indigenous women's movement titled Who She Is. Please join me in welcoming Mr. Jordan Dresser, the chairman of the Northern Arapaho Tribe.
Chairman Dresser, it's an honor to have you with us here today. Thank you for joining us. Chairman Burkhart,
Thank you, Mr. Speaker. Privilege of the floor.
please proceed.
Mr. Speaker, in the North Gallery, ladies and gentlemen, is Carbon County Commissioner John Espy. And I like doing this because this is the only time I get to introduce anybody from Carbon County, it seems. So Commissioner Espy, welcome.
Welcome, Commissioner Espy. Yes, Representative Oakley.
Thank you, Mr. Speaker. I have the honor today of introducing two very special constituents and future voters. This is Zayden and Gabe Cooper. I work with their parents, Danny and Noel Cooper, and they're both just tremendous assets to our community. So Zayden Cooper, if you'll give a wave, was named Student Scholar of the Month in March 2021 from Ash Grove Elementary in Riverton. Zayden excels at math, science, and he loves his soccer. Go Stallions. And and Gabe Cooper, if you'll give a wave, was the Riverton Youth Soccer Association Spotlight Player. His coaches noted his strong work ethic and can-do attitude. Gabe is in 6th grade and he takes advanced math classes at Riverton Middle School. Both of these are the grandsons of Lori Urbikite. So please welcome Gabe and Zayden Cooper.
Well, we're so glad you're here with us today, and I hope Grandma spoils you a little bit while you're here. Great. Anything else? Anything else? So we're at that order of business of the reading and signing of enrolled acts. The first act is 50. Reading clerk.
House Enrolled Act 50, being original House Bill 133. An act relating to online sports wagering, authorizing online sports wagering, providing for regulation by the Wyoming Gaming Commission, imposing fees, requiring rulemaking, creating an account, provided for the collection and distribution of revenues from online sports wagering to the state, providing for a continuous appropriation, creating penalties, specifying that fantasy sports contests are not gambling, and providing for effective dates, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act 50, being original House Bill 133. I have so signed. Congratulations, Representative Walters. Next enrolled act is 51.
House Enrolled Act 51, being original House Bill 112. An act relating to game and fish, providing for the issuance of pioneer trapping licenses as specified, and providing for effective dates, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act 51, being original House Bill 112. I have so signed. Congratulations, Representative Clausen. Next enrolled act. In 20 and 30 years, you'll be eligible for that, I think, Representative Clausen. Next enrolled act is 52.
House Enrolled Act 52, being original House Bill 101. An act relating to elk feed grounds, authorizing the permanent closure of an elk feed ground authorized or administered by the Wyoming Game and Fish Commission only upon order of the governor, requiring the recommendation of the commission and comment by the Wyoming Livestock Board for the closure of an elk feed ground, requiring a public meeting, authorizing the governor to temporarily close elk feed grounds under emergency circumstances, authorizing the Wyoming Game and Fish Commission to contract or lease private and state lands for relocating elk feed ground sites, requiring the Wyoming Game and Fish Department to develop plans for alternate elk feed ground sites as specified, requiring a report and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act 52, being original House Bill 101. I have so signed. Next enrolled act, congratulations, Representative Summers. Next enrolled act 53.
House Enrolled Act 53, being original House Bill 85. An act relating to crimes and offenses, creating an offense for the non-consensual dissemination of an intimate image, specifying elements and penalties of the offense, providing definitions, providing exemptions, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act 53, being original House Bill 85. I have so signed. Congratulations, Representative Stith. Next enrolled act 54.
House Enrolled Act 54, being original House Bill 68. An act relating to the Wyoming Statutory Foundation Act, amending definitions, amending provisions related to the beneficiaries, liabilities, obligations, debts, and distributions under the act, making conforming amendments, authorizing the issuance of units and shares of statutory foundation, repealing definitions and provisions related to foundation purposes, beneficiaries, and the liability of protectors, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act 54, being original House Bill 68. I have so signed. Congratulations, Chairman Greer. Reports from standing committees. We don't have any. Follow the script. Members, with that order of business of bills on second reading. First bill for our consideration. Senate File 4.
Senate File 4, sponsored by Transportation, Airport Districts, and an act relating to aeronautics.
We do have amendments. Representative Newsom, I have you as the First Amendment on Senate File 4.
Thank you, Mr. Chairman. What this amendment does is what I mentioned when I spoke yesterday. I have left agriculture as an exemption, but deleted commercial and industrial as exemptions, as both of these types of property tend to benefit from having airport service. So, and from the commercial realm, being able to get people in and out in a community like mine, where our tourists fly in and out, supporting our commercial district, and industrial, where goods are moved in and out of the community. So I don't think I moved the bill. I move that when the committee of, I move House Bill number 2, amendment to Senate File 4, and ask for your approval. Thank you.
All right, so members, we are on Senate File 4. This is second reading amendment number 1 that the movement has brought to us. Any discussion on the amendment? Discussion on amendment. Chairman Burkhart.
Thank you, Mr. Speaker. I would ask the body to resist this amendment. The choice is real simple. Industrial users don't get to vote on the system, or on these districts rather. They get to pay for them with no vote, no input. So the choice is easy. You force them to pay for something that they don't get to vote on or not. So on and against the amendment.
Any other members? Any other members on the amendment? On the amendment. Representative Yin.
Thank you, Mr. Speaker. I think the choice is easy, that those that can be included from benefiting from an airport should also pay towards the benefit that they get. And so the county commissioner can help decide that. So on and for the amendment. Thank you, Mr. Chair.
Representative Brown, first time. On
Thank
the
you, Mr.
amendment.
Speaker. On and against the amendment, and just think back to yesterday's discussion about this, and my argument it was and still is that we're asking industry to pay for something that they do not have a say-so in when it comes to the vote. And when you include this industrial side of things, the other thing that concerns me is you think about what industry means, industrial side of things. You start talking about the Trona mine, you start talking about the coal mines, and they say, well, we can talk with the county commissioners and they can carve out those areas if they don't want them to be in there. Well, every time they open up a new section, whether it's underground for Trona or above ground for coal, they're not going to be going back and updating this. So they may be exempted now. The county commissioners may look at this right now and say, okay, well, we're going to carve this out. But when they get to this section, we're going to start hitting that with 1, 2, or 3 mills. I really we need to have a serious discussion about not asking industry to pay for everything all the time. That's what we're doing with this amendment. The amendment, I have another second reading amendment coming up after this one. The discussion yesterday was, hey, commercial uses this. We should absolutely ask commercial. Okay, let's have that discussion about commercial. But when it comes to industry, the people that are already paying our bills, we're going to ask them to pick up the tab for yet another one. I can't support this, and I hope you can vote no.
Thank you. Representative McGuire, first time on the amendment.
Thank you, Mr. Chairman. So we have 2 for and 2 against. So I guess I'll be the tiebreaker and would recommend adoption of the amendment. And again, we're here because, yes, in the state of Wyoming, we do have an issue, and that is how our local municipalities and our local entities raise revenue. And it's a real problem. And if you look at the current budget that we just agreed to, we take $10 million away from the local entities. And so we taketh away but we don't give them the opportunity to replace or counterbalance or anything else. And when you talk about fairness, as our system exists, the fairness comes from meeting with the local county commissioners and making sure, and I can assure you that the county commissioners are very aware of their industrial and commercial clients or constituents, and they do give them a fair hearing. So this is a tool. It's an opportunity for the local airport to go to their county commission, plead their case. If the appropriate steps are followed, it can be brought to the voters, and the voters will get to make the final decision. So on and for the amendment. Thank you, Mr. Chairman.
Thank you. Any other member for their first time? Member for their first time, second time, second time? Chairman Burkhart.
Thank you, Mr. Speaker. Just to remind the body that in the current, I think the acronym is ARPE funds. There's $8 billion from the federal government being set aside for airports. So I guess nationwide, that's not enough money. So on and against the amendment.
Any other members? We're on second time on second reading amendment number 1, Senate File 4. Second time to the sponsor, Representative Newsom.
Thank you, Mr. Chairman. I think as we talk about those federal funds that are coming toward our state and possibly toward our airports, that's a nice shot in the arm. But this is a long-term solution. This is a solution that goes beyond what happens tomorrow and beyond what happens in the next 5 years. This solution goes to help our communities be able to continue to have air service, which is so important to the industrial side, because I know in my community, there are oil executives and members of industry that fly in and out all the time. When I'm on a economic development task force, and one of the first questions that we're asked by somebody looking to relocate is, what's your air service like? Those are important pieces. So I am on and for the amendment, on and for the bill.
Thank you. Members, we are voting in second reading amendment number 1, Senate File 4. All those in favor, please say aye. Aye. Those opposed, no. No. Chair is in doubt. All those in favor, please rise. Thank you. All those opposed? All those opposed, please rise. (2530), the amendment is not adopted. We have another amendment. Representative Brown.
Thank you, Mr. Speaker. I move second reading amendment number 2 to House Bill or to Senate File 4 and ask for your favorable consideration on this one. And ladies and gentlemen, this was the discussion that we had yesterday, that let's not ask industry to pay for this, but the commercial properties that are in there and utilizing this and that are going to benefit from this, the tourism dollars and everything else along those lines, those are the people that are willing to pay for this. I even heard that on this floor yesterday. So all this is doing is taking the amendment that passed yesterday and striking out industrial. So we're still going to have the residential and the commercial people paying the bills, and it strikes out the industrial side of things. So Mr. Chairman or Mr. Speaker, that's the amendment.
Discussion on the amendment. Discussion on the amendment. Representative McGuire. No further discussion. No further, any other member, first time on the amendment, first time, second time, seeing none. Members, we are voting on second reading, amendment number 2, Senate File 4. All those in favor, please say aye. Those opposed, no. Amendment is adopted. Senate File 4 having read 2 separate times. The question is, shall the bill be read a third time? Hearing no objection, so ordered. Next, Senate File 66.
Senate File 66, sponsored by Senator Cooper. Slayer rule applied to joint ownership. An act relating to wills, descendants, estates, and probate code.
We do have an amendment. Representative Duncan, Vice Chair Duncan.
Thank you, Mr. Speaker. I respectfully would like to withdraw my amendment.
Senate, the amendment is withdrawn. Thank you. Senate File 66 having been read 2 separate times. The question is, shall the bill be read a third time? Hearing no objection, so ordered. Next, Senate File 75.
Senate File 75, sponsored by Senator Landon. Protective orders, amendments, and act relating to the courts.
Senate File 75 has amendments. Representative Stiff, please proceed.
Mr. Speaker, I move second reading amendment number 1 to Senate File 75 and ask for your favorable consideration. So we had a long discussion about this bill. This is an effort to fix it or make it less bad. So the anomaly and what makes this bill difficult to read, I think, is that the statute that it's amending has several cross references to other statutes. And under current law, if there is a sexual assault order of protection, if you violate that, it's a misdemeanor. But if it's a stalking protection order, violation of it is a 10-year felony. Okay, and it's the potential of a 10-year felony for violating a stipulated order that has no factual basis that I was objecting to yesterday. So what this amendment does is it says, well, look, even if you don't have a lawyer, if you go to court and if you agreed to some kind of order, it's still an order of the court and deserves some respect. And so this amendment would say that if you voluntarily enter into a stalking order of protection with no factual admission, that if you violate it for your first violation of it, it's a misdemeanor, not a 10-year felony. And so I think that strikes a more reasonable balance. So that's what this amendment does. If you have a second or subsequent violation of this order that you've agreed to, then it would revert to sort of the original, or it would be a 10-year felony potentially on the stalking. So this amendment, to be clear, only applies to stalking orders of protection. Does not apply to domestic violence orders of protection, does not apply to the sexual assault orders of protection. So the amendment's designed to be pretty narrowly tailored. So 1 and 4.
Thank you. Any member for their first time? First time, Senate File 75, second reading, amendment number 1. Chairman Zwanitzer.
Thanks. Just a question, Mr. Speaker. So, because I don't want to make sure that, if something really bad could happen here, right? That is there any possibility? I still want to make sure that if you have a nefarious thing going on, right? And the quickest thing to do is put one of these orders in place, and someone's life really is at risk. I mean, there may be a good reason that you get a felony stalking charge for even a first violation. I just want to make sure this doesn't prevent the most serious of situations that we could have, that if it was in fact that serious, we're not limiting, that everybody has the right to, go stalk somebody one more time without punishment in a really dangerous situation. So just some clarity that the law would still allow in the most extreme situation to get around this if somebody truly should be charged for felony stalking and a life situation is at risk.
Thank you. Any other member first time? First time, Representative Oakley, first time on the amendment.
Thank you, Mr. Speaker. I guess I would say on and ambivalent as far as the the amendment. I would say this, if it's a compromise, I would be willing to go along with this as long as we can pass the bill. Because it's, in discussing it, without this, what it does is it ties that respondent's hands. And I know everybody is talking about, due process for the defendant, but what I don't think is understood is that without it, that person, you take that person's options away not to have an evidentiary hearing, which that affects their rights. Probably a huge percentage of the orders are stipulated and entered into this way. And if we don't do this, it takes away the opportunity for the judge and for the respondent to even do that if it's what's in their best interest. So it's important to pass the bill if we want to have a compromise that if it's a stipulated order, that doesn't rise, will never rise to the level of a felony in that instance. I would be willing to make that compromise in order for the bill to pass. So still on an ambivalent, but for the bill.
Thank you. Any other members? Representative Brown.
Thank you,
Vice
Mr.
Chair
Speaker.
Brown.
Thank you, Mr. Speaker. Slightly less ambivalent, and I will slightly push back. I appreciate the good member of appropriations for bringing this and trying to find that medium spot in this discussion, because this is really an important discussion, right? And I talked with quite a few people about this between the committee of the whole discussion yesterday and even this morning as I was walking in here, had a discussion with the director of the area that actually helps the victims with this and what their opinion and what their thoughts were on this. And as I look at this, one of the bigger concerns that I have, and again, it's as far as the concerns go, it's kind of not that huge, but what we're ultimately saying is to what the good chairman of corporations just said, that in a situation where you do have a stalking situation, you are ultimately tying the hands saying, I can only charge you with a misdemeanor if you violate this. So we're giving that opportunity of potentially tying the hands of somebody who's potentially very dangerous. And as some of the information that I got yesterday, stalking actually has the highest propensity for anything leading into homicide. So when we start talking about these stalking things, it becomes more dangerous. And I think it becomes more concerning to me that we're going to tie the hands of the judiciary to say the prosecutors can only charge with a misdemeanor on the first reoffense. That being said, the discussion that I had with some of these other people is the people that get involved with these, a lot of them don't have the chance and the opportunity to hire an attorney. And they're signing these things in an effort to try to stay away from going into the courtroom and trying to, hey, I'm just trying to play by the rules here. But what they're doing is they're signing on to something and they may not know exactly what they're signing on to. And so that's the conflict that I think a lot of us are having, and at least my opinion. So I'm not pushing back too hard on this because I think it's a good compromise. But I do think that we're in a situation here where we are tying the hands of the prosecutors and the judge, and particularly possible dangerous situations for the victims. When we're talking about stalking, it does have a higher propensity to have homicide attached to it in the later end. So, if we have a stipulated agreement and somebody decides, well, I'm only going to be charged with a misdemeanor if I go do this, it's not that big of a deal. You basically kind of giving them a free strike on this order. So slightly less ambivalent, pushing back ever so slightly to the good member of appropriations. Vote your conscience.
Thank you. Any other member ambivalent or not on the amendment? Representative Duncan.
Thank you, Mr. Speaker. In plain speak for everybody, if you're ambivalent about this amendment, it's okay. But we need this amendment, and what's more important is the bill. So in the bigger picture, is up or down on the amendment is kind of irrelevant, but the bill is very important, very important. So it doesn't hurt the bill, is what I want to say. Thanks.
Thank you. Representative Henderson, first time on the amendment.
Thank you, Mr. Speaker. On and against the amendment, because I think what's important here, and the bill is very important, is the victim and whether they get due process. And I think that's provided for. I think the amendment as it is really kind of doesn't help the bill. I think the bill as it stands, the gross version is ready. There's another amendment coming that I'm concerned too, but this one I would be on and against. Thank you.
Any other member? Any other member first time on the amendment? Any other member first time, second time, second time to the sponsor? To the sponsor, Representative Stiff.
Mr. Speaker, thank you very much. I guess I have somewhat difficult time understanding the comments from the representatives from District 9 and 55 that we have to protect this poor, vulnerable population of helpless prosecutors. I just don't quite get that, you know? I mean, if they've got a bad guy, they've got all the tools of the state, the government to go prosecute them. What we're talking about here is a civil case where someone is asking for a civil stalking order of protection. And the question is, you know, can the respondent agree to it without admitting guilt or fault or any facts? If we let that happen, let's just make it a violation of that order, at least for first offense and misdemeanor. So on and forth. Thank you.
Thank you. Members, we're voting on second reading, amendment number 1, Senate File 75. All those in favor, please say aye. Those opposed, no. Senate File, second reading amendment 1 has been adopted. We have a second amendment. Representative Conley, please proceed.
Thank you, Mr. Speaker. I move second reading amendment number 2 to Senate File 75, and I ask for your favorable consideration. Friends, our discussion yesterday about the bill, I was very much taken with it. I was honestly a bit confused with the former bringer of an amendment scenario and how it would cause harm. And I listened to the testimony quite a bit. And what I heard and I was compelled by was the concern that a respondent, which you could call either a perpetrator or an alleged perpetrator, but the respondent might not have enough knowledge to make a knowing and voluntary stipulation. And I'm reading right from the bill. And that was a concern. And that was a concern that I listened seriously to, that someone might just sign a document and not really understand what that signing of the document meant, or what was the exchange, or what were they giving up for signing that document. And so the question then is there a remedy for that? And the answer is due process. We heard that yesterday, we heard that again today. The remedy for a concern about not having enough knowledge is more due process. So what this amendment does is add in a level of due process. What it says is that before we begin by saying a respondent may make a knowing and voluntary stipulation, we add in the clause, after a respondent has been advised in writing of the nature of an evidentiary hearing, including benefits and detriments of a hearing as opposed to a stipulated agreement, and then we go on. That's the exchange. It's an evidentiary hearing versus a stipulated agreement. The individual needs to understand what an evidentiary hearing is and sign a document that then goes into that folder. So this takes care of, or it doesn't take care of, but it is a step. It's an additional step of due process for that respondent. And so with that, I take any questions or ask for your favorable consideration.
Thank you. Chairman Olson, first time on the amendment.
Yeah, thank you, Mr. Chairman. And I guess I just have a couple of questions about the amendment because I appreciate the issue that the amendment is attempting to address. The question I have is the heart of the amendment requires the respondent to be informed of what he or she is waiving before stipulating. The question I have is who is going to advise the respondent? And let me just give a little bit of explanation there, because if it is a pro se respondent, a person who has no attorney, and then a stipulated order is presented in front of them, are we just saying that that respondent has to go and seek counsel before signing it? And if they sign it without counsel, then it's void? Because I think the amendment works in the universe where everybody has a lawyer. In the universe they don't have a lawyer, I'm not sure how we navigate that. And then, or if it's not the attorney, are we then, is the process that we think that the judge is going to make sure that the respondent was advised by counsel before signing the order? And that may be a question of process on how these work, because if you've waived the hearing, I don't think if there's no hearing, the person doesn't appear before the judge. So the judge doesn't get to ask the respondent, did you have counsel? So I think the amendment might actually create the hearing then, if somebody doesn't have an attorney, because the judge would have to bring the respondent in and say, do you understand what you stipulated to, and did you have counsel? Otherwise, the judge would never be able to sign one of these. But maybe ultimately, who's advising the respondent is the question.
Thank you. Any other member first time? Members are on first time, second reading, amendment number 2. First time. Representative Craigo, first time.
Thank you, Mr. Speaker. And just a question for the bringer of the amendment. I actually like this idea, but I'm a little bit worried, as the former speaker was talking about the process. Does this mean we have to have the respondent show up in court? Because often, as how these things work now, you would sign a stipulation and neither party would show up for court. The judge would then sign the order and it would go into effect. And I'm not sure it's necessarily a good policy choice to have the respondent and the petitioner, the complainer at this point, in this being in the same place at the same time. It may contravene what we're trying to do with the bill.
Thank you. Representative Knapp, first time on the amendment.
On, and I believe for the amendment. This is a confusing bill to me, and the amendment offers a protection. It's basically a bill that turns a civil stipulation violation into a criminal stipulation. And often, while I'm concerned for people that have been involved in a stalking situation, or someone who's been involved in a domestic violence situation, to be able to have this tool in a stipulation, it gets very confusing, because we also have to remember the rights of the respondent. And the respondent very often does not have an attorney representing them. So they might be signing something that they do not understand that becomes criminal. And so I think the amendment's an important piece. I don't know that it solves everything, but it adds a little bit of defense to a person who may not understand what they're signing on to. So thank you.
Thank you. Any other member first time? We're on first time. Seeing none, second time. Representative Olson, Chairman Olson.
Yeah, Mr. Speaker, as confusing as this is, I'm here to answer my own question now, because I think I got to the answer. And remembering how this works, so these stipulations are based on a form. So there's a form that's already created that ends up in front of the respondent and the petitioner. And it's designed to be a pro se form. It's basically check the box, fill in the blank kind of form. And now that I think about it, it would mean that all the court has to do is add one paragraph to the form. And the paragraph would say that the respondent had an opportunity to review this form with counsel. And if you don't, you're waiving that. And that's very typical in any agreement in a pro se matter, at least in my practice of law. And I'm sure this would be common in every attorney's practice of law. Anytime you put a document in front of somebody who doesn't have an attorney, you make sure that there's a paragraph that says, and you read it to them, and they had an opportunity to understand that they should have had a lawyer review it if they wanted to. So now that I think about it, all it is an addition to the form, would be my assumption. So I think I'm actually okay with this amendment.
Any other member, second time? Representative Craigo, second time.
Thank you, Mr. Speaker. And listening to the comments we just heard, and also in speaking with the sponsor of the amendment, I think my concerns have been alleviated as well. And so I would be on in favor of the amendment. Thank you.
Anyone else on in favor of the amendment who's spoken for the first time? Second time. Madam Minority Floor Leader, bring it home.
Thank you, Mr. Speaker. We obviously had a nice kumbaya moment back here. What this does is it adds in a layer of due process and it's workable. And with that, I would ask for your favorable I vote.
Thank you. Members, we are voting on second reading amendment number 2 to House Senate File 75. All those in favor, please say aye. Those opposed, no. The amendment is adopted. Senate File 75 have been read 2 separate times. The question is, shall the bill be read a third time? Hearing no objection is so ordered. Next, Senate File 78.
Senate File 78, sponsored by Senator Pappas. Real estate appraisers, continuing education, an act relating to real estate appraisers.
Senate File 78 having been read 2 separate times. The question is, shall the bill be read a third time? Hearing no objection is so ordered. Next, Senate File 85.
Senate File 85, sponsored by Senator Ellis. Property tax reporting and exemption, an act relating to property taxation.
We do have an amendment. Representative Larson, Dan.
Mr. Speaker, thank you. I move second reading amendment number 1 to House Bill Senate File 85, sorry. The amendment just cuts in half the civil fee. And I think that's a good part to this amendment. I think $500 or $250 would be plenty. That would be 5 days or $5 every day they fail to file their report, which is due on March 1st. If I am not correct, somebody can correct me on that. And that would be 50 days they have yet to do that. The next part of it deletes the exemption. And I think the exemption is just very confusing for those businesses that are paying these taxes. I mean, $2,400, it could be one computer. Then you go buy another picture to put on the wall, and now you're above that by just very little. But I think it's really tough for a business to not know if he should be doing it, if he doesn't get a notice. I think it's difficult. The other part is, why did we pick 2,400? Why didn't we pick 20,000? You know, I think every time they say, well, we're cutting down 7,000 letters we got to send or postcards, they'll just say it again after they get this passed. So I think the exemption ought to be taken away. So hopefully you'll vote for the amendment. And if we keep the amendment, I'm for the bill.
Representative Newsom, for your first time on second reading amendment number 1, Senate File 85.
Thank you. I would like to divide this amendment.
All right, your divisions, please.
The first division would be lines 1 through 9, in addition to lines 12 through 22. The second division would be line 10, along with lines 23 through 25.
Would you repeat it again? I've got several marks on here. So lines, repeat it again, please.
Lines 1 through 9.
Thank you. That's Division 1.
No, as well as included in Division 1, lines 12 through 22.
Okay, thank you.
And then in the second division, line 10, as well as lines 23 through 25.
Okay, so members, as I understand it, Division 1 is lines 1 through 9 and lines 12 through 21. And Division 2 is lines 10 and 11 and 23 through 25. I think line 1 needs to be also in Division 2, lines 1 and 2 needs to be in Division 1, but that's maybe technical because the exemption, but that's fine. So what would you like to begin with?
I would like to begin with Division 1.
Division 1, please proceed.
And I would ask for your aye vote on Division 1. This simply takes the penalty from not being a criminal penalty, being just a fine. and lessening the fine by half.
Further discussion on Division 1. Further discussion on Division 1. Division 1, Representative Gray.
Thank you, Mr. Speaker. I urge and I vote on Division 1. I like it. The bill sponsor likes it. I like the previous commenters' comments. I think we've got a good division here. So thank you.
Chairman Zwanitzer, Division 1.
Thank you, Mr. Speaker. I always hate it when I'm on the other side of everybody I like. But I just do want to remind the body, and it's not something to kill the bill over. So if you say vote aye, that's fine. I just wanted to point out current statute right now is the misdemeanor and the up to $500 fine. They changed that to take out the misdemeanor and make it $10 a day, not to exceed that 500, which was in line with, previous statutory intent. And so we're just reducing it, which is fine. I think there will be a point though, when someone says, well, they can't jail me anymore, and the most I'm gonna have to pay is $250. It's not, I'm not even gonna file, and they're gonna have to do a major court action to even come after me and investigate. So, I mean, I don't think there's any stick or teeth in the statute anymore if we take it all the way down to $5 and $250. And I believed when I looked somewhere in the interim, we hadn't changed this for 30 years. And so inflation would say, that 500 should actually be increased. So just to give you the other side of the argument, vote your conscience, but I'll be voting no, just because I want to make sure there's a little bit of teeth in the law for people to do what they should be doing. We've had this policy in the body now that for a long time, we don't like to raise taxes. And so the policy was, I think from this body previously, that if we're not going to raise taxes, we need to be doing everything we can to ensure people are paying the taxes they should already be paying. And then I look at bills and the amendment like this, and now we're saying, well, now we don't even think people should be paying their fines or the taxes. What we previously have in statute, let's reduce them even more. So if we're not going to raise taxes and we're not going to get people to pay what they owe us, or at least in providing this personal property tax. And now we're saying, well, there shouldn't even be a penalty that is that severe if you don't pay the money that you should be paying already. We're just kind of in this downward cycle, and I'm not sure where it stops. So I would encourage your no vote, but certainly doesn't harm the bill either way if you vote it up.
Any other member? Representative Baker, Division 1.
Thank you, Mr. Speaker. On and for Division 1. And I just want to make a quick comment about the teeth in the existing statute that still remains. What you don't see in the bill is subsection A, which says any person interfering with the county assessor or deputy county assessor in the discharge of his duties, or any person refusing to allow the county assessor or deputy county assessor or representative of the Department of Revenue to examine any property pursuant to 3913-103B is guilty of a misdemeanor. So there is still teeth in the law. Thank you. On and in support of it.
Thank you. Any other member? First time, Division 1, Representative Yin.
Thank you, Mr. Chairman, Mr. Speaker. So on and against Division 1, I actually really like the bill. I think the problem with lowering the amount of fines. So the bill, even with or without this division, still removes the misdemeanor for this portion, which is great. I think that's great. The problem with lowering the fine is that you as the good chairman of corporations said, you make it easier to incentivize you to not file if you don't think you need to file. And so that actually ends up putting more burden on the assessors, right? Because then they'll have to put out more notices each time as someone decides not to file. So I think keeping that $500 number is still really useful to ensure that the assessors aren't burdened with sending even more notices out to people who don't file. And so I would ask you to vote down Division number 1. Thank you, Mr. Speaker.
Any other members? Division 1. Members, first time Division 1, first time, second time Division 1, second time, Representative Newsom. If you would like to go, you don't have to.
Vote aye.
Any other members? All right, members, we're voting on Division 1, second reading amendment number 1, Senate File 85. All those in favor, please say aye. Aye. Those opposed, no. Amendment, division is adopted. On Division 2, members, Representative Newsom.
Thank you, Mr. Chairman. Division 2 essentially just takes out all of the language that allows people that have less than $2,400 in fair market value. It just eliminates all of that because I feel that there is so much confusion as to how that is implemented and also how you get back into the system. So for example, I had a candy store back in the day and my fair market value of my fixtures was minimal. It was under that $2,400 mark. At one point I decided to grow bigger and I spent tens of thousands of dollars in candy making equipment. So had I not been getting that tax assessment, I guess the question becomes, how would I know that I needed to get back into the system? And in this, there doesn't seem to be a clear way for me to report that additional expenditure and that additional equipment that would need to be taxed. And so although I am in favor of getting some of those low taxpayers off the rolls, I guess I wonder how we get people back on the rolls when they spend more money. Thank you.
Thank you very much. Any of the members for their first time on this division? Chairman Wilson.
Thank you, Mr. Speaker. I would suggest a no vote on this division, and I will admit that I am actually a small business owner that would fall under this category. But I'm one of a large class of people, I assume. For my translation business, about all I have is I have a computer, a filing cabinet, some professional books, and about 4 years ago, I think my property tax was about $3.58. I mean, it's really embarrassing. And then I bought a computer. So now it's up to like $9. But I'm really quite sure that they're spending a lot more effort collecting my $9 than it's worth to them. And that's the entire point of this bill, to save them the effort of chasing after these little dinky amounts. Certainly, if you are an honest and alert business person, if I decide after I retire from the legislature that now I can have a 2,000 square foot business of translators, you know, I know how to find the assessor's website and find a form and send it in. I think that it's really valuable to maintain this. In fact, it was really the whole point of the bill. So I would say to vote no on this because we don't want to delete it.
Thank you. Representative Larson, Dan.
Mr. Speaker, thank you. I would encourage an aye vote on this division. I still think it's just really confusing for the business to, you know, that $2,400, and then you don't get a notice every year. So let's go down 5 years later, you know, and so is the assessor going to go out there and have to start hunting these things down? I know it's just a small amount of dollars. I've also heard that they're not going to get rid of employees. They'll still keep the same number of employees. They have it on their computers. It gets sent. Just vote aye on the division.
Representative Duncan, first time on Division 2.
Thank you, Mr. Speaker. I'm in agreement with the chairman of labor. This would affect me and a lot of other small mom and pop businesses, realtors, you know, smaller businesses. Yeah, it's a little bit of money, but every little bit contributes. So I don't see it necessary. I think it's cumbersome. I'm not quite understanding why and where the process is going. So I urge a no vote on this division.
Thank you. Representative Gray, first time. Division 2.
Thank you, Mr. Speaker. I appreciate it. Mr. Speaker, I really urge a no vote on this division. So again, we're talking about personal property tax. You got 38,000 existing tax accounts. This would eliminate off the roll 7,000 of them. It's going to be clear when they send out that notice on the existing account. It's going to say, hey, if you're under 2,400, you're good. And if you've got an armoire or a computer, I mean, if you're running a small business, it's going to be good for you because you won't have to pay this tax. And so this is pro small business, this removal of this, creating this de minimis exemption. Let's keep it in the bill. And I urge a no vote on the amendment. Thank you.
Thank you, Representative Knapp.
Thank you, Mr. Speaker. I would vote aye on the division. I know for some it seems menial, but this is about consistency. This is about creating yet another exemption for people. This is a tax that exists. It's a form that exists. It should apply to everybody, not just a few. My businesses would have fallen under the $2,400 exemption, which I would say is arbitrary, but they've turned into $1 million businesses. If I'd fallen off these rolls, I'm not so sure I'd be on a roll in the future. So let's keep consistent with what we do. Stop creating exemptions where we didn't need to, and especially ones that are arbitrary. So thank you.
Thank you, Chairman Zwanitzer, first time.
Thanks, Mr. Speaker. I ask you to vote no, and echoing the good representative from the center part of the state. Not only is this business friendly to your smallest mom and pop businesses, and you know, it would take out them having to file the forms and list every officially, 10, file cabinet, $5 item. And, people do this, right? They write 8-page lists in spreadsheets, listing every single thing people want to comply, and it's still under this $2,400 threshold. But the inverse side is the bureaucracy that are actually our county assessors are saying it costs more time and money and effort for us to do this, and we actually lose money. So by voting no on this amendment and keeping the $2,400 in the bill, you're helping small business. You're cutting down on bureaucracy and government expense. That's the whole purpose of the bill, was really to, help small businesses. And it's amazing when government says, hey, we don't, want to spend our time and effort, trying to go after people for $8 here, $9 there. It's not worth our time and our effort. We can spend that on better things, assessing the county. So it's a great bill that eliminates government bureaucracy and helps small business. Vote no on the amendment.
Thank you. We're on Division 2, Representative Wharf, first time.
Mr. Speaker, thank you. I urge the body's support of this amendment. I really wrestle with exemptions, and I've never been comfortable anytime we exempt something or someone. It's one of those things that just I think is problematic. So I would urge the body's support of Division 2 so we can support this bill. Thank you.
Any other members? First time, Division 2. First time on Division 2. Second time, Division 2. Second time, Chairman Wilson.
Thank you, Mr. Speaker. Just a couple of thoughts there. And I wasn't fast enough in the Constitution, but we have certain statements in the Constitution that if we ever had an income tax, we'd have to exempt the other things that you paid. We have exemptions for nonprofit organizations. Any bar in our tax code is essentially, I don't say random, but your federal income taxes, they don't collect below a certain level. So I don't think that that's a big surprise. And I guess the other suggestion that if they do away with sending you a form every year, then sometime you might not remember that you had to pay taxes. I remember every year, April 15th, that I'm supposed to pay my federal income tax. The folks in DC don't actually send me a little mailer. I mean, they used to mail you your tax things. Now it's supposed to occur to you that you pay your taxes. And frankly, I think if you are clever enough to run a business, you're probably clever enough to remember to pay your taxes and to consider whether you might owe something. I really don't understand the reasoning for being so willing to keep collecting taxes from people. So again, against the division.
Thank you. We're on second time, Division 2, second time, Representative Gray.
Thank you, Mr. Speaker. One other thing I wanted to say that I missed on the first time, I'm looking at a handout right now, and almost all of our surrounding states except one have some form of de minimis exemption. In the West, it's all but 3 of them. So this works in other states. I know we don't just go solely off that, but it does work. Let's do a good thing for small business here, keep the exemption in, and I urge a no vote on the amendment. Thank you.
Anyone else? Second time, Representative Larson, Dan.
Mr. Speaker, thank you. I encourage an aye vote on the division. I still think we ought to be consistent, send out the notices to everyone. They might, it's on their computers already. They just send them out and they're not getting rid of employees if you do get rid of these 7,000 notices. Vote aye.
Any other member? Any other member? Second time. Seeing none, members, we are voting on Division 2, second reading amendment number 1, Senate File 85. All those in favor, please say aye. All those opposed, no. The division has not been adopted. Senate File 85 have been read 2 separate times. The question is, sorry, we do have another amendment. My apologies, Representative Gray.
Thank you, Mr. Speaker. I appreciate it. Mr. Speaker, I move second reading amendment number 2 to Senate File 85 and ask for favorable consideration. So what this amendment does is it deletes on page 2 lines 10 and 11, and then on page 2 line 9 just the word civil. It's that last sentence there, and it was a good catch. Article 7, Section 5 of the Constitution directs fines and penalties to the public school fund of the counties, not to the general fund. So we want to make this clearly in accordance with the Constitution. So urge an aye vote. Thank you.
Thank you. Any discussion on the amendment? Discussion on the amendment. Members, we're voting on second reading amendment number 2, Senate File 85. All those in favor, please say aye. All those opposed, no. The amendment is adopted. Senate File 85, having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection is so ordered. Next, Senate File 111.
Senate File 111, sponsored by Senator Anderson. School of Energy Resources, budget submittal, and act relating to University of Wyoming.
Senate File 111, having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection is so ordered. Next, Senate File 114.
Senate File 114, sponsored by Senator Boner. State land leases, and act relating to state lands.
Senate File 114, having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection is so ordered. Next, Senate File 118.
Senate File 118, sponsored by Appropriations, Federal Emergency COVID-19 Relief Funding, and act relating to the emergency expenses of government.
Senate File 118, having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection is so ordered. Next, Senate File 126.
Senate File 126, sponsored by Senator Cooper, Real Estate Subdivisions, Easements, Requirements, and act relating to planning and zoning.
Senate File 126, having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection is so ordered. Next, Senate File 139.
Senate File 139, sponsored by Senate Appropriations, Community-Based In-Home Services Program, and act relating to community-based in-home services.
Senate File 139, having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection is so ordered. Next bill is Senate Joint Resolution 3.
Senate Joint Resolution 3, sponsored by Senator Cooper, Federal Suspension and Orders on Oil and Gas Production, a joint resolution requesting Congress and the federal government to reserve federal orders and actions that inhibit and safe development of oil and gas in Wyoming and that negatively and disproportionately impact Wyoming citizens and industries.
Senate Joint Resolution 3 have been read 2 separate times. The question is, shall the bill be read a third time? Hearing no objection, it is so ordered. Representative Gray.
Thank you, Mr. Speaker. Pursuant to Rule 4-7, I move that Senate File 133 be referred to Committee of the Whole. Thank you.
Thank you. So members, as the Representative Gray cited the Rule 4-7, it allows the body to refer a bill that has not been assigned to a committee, meaning the speaker, in that case, did not assign it to committee, so the body can take that action up. It is a debatable motion. It is debatable, and it will be a majority vote. It's a majority vote, and we will have a recorded vote that's been requested, and there are seconds on that. So we will have a vote. So discussion on the motion. Representative Gray.
Thank you, Mr. Speaker. This bill passed 22-7 in the Senate. It's a pro-life bill. I really feel we have pro-life majorities on both floors and in the Health Labor Committees on both sides. It's really been 30 years since that's been this way, and may even be more than that. But my history beyond that. But I just am not understanding why this would not be brought for debate in committee of the whole. So I think it should be. Let's debate this bill. It's a strong bill, passed 22-7, and it's a pro-life bill. Thank you.
Thank you. Other members? Mr. Majority Floor Leader Summers.
Mr. Speaker, thank you. On and against the motion. I think as you think about what we do in leadership and the bills we look at and the bills that end up, whether it's you're a chair or whether you're majority floor leader, or whether you're speaker, you have to kind of look at all of the issues and decide what comes up. So I would urge you to resist this and support your speaker's decision on and against.
Chairman Olson, first time.
Yeah, thank you, Mr. Speaker. I'm on and against the motion. I'm going to stand with the speaker on this. And, you know, I'm a pro-life through and through voter, consistent. But to me, this is a question of process. Just give you an example. You know, I'm the majority whip, and I had a House bill that was never assigned to a committee. You know, that's the process. I didn't bring a motion to bring that bill out. I just respected that process, and not trying to put ill intent on the bringer. Don't get me wrong. I'm just using it as an example that I don't think it's a leadership versus rank and file kind of concept. It's just the process. And so I'm just going to stand with the speaker on the process. We have a lot of bills. We have a short agenda. And sometimes that's just the way it goes. And I've had it happen to me. So just on and against the motion. Thank you.
Thank you. Any other members, any further discussion on the motion? Thank you. Representative Bear.
Thank you, Mr. Speaker. I do respect the speaker's decisions, but this really comes down to maybe a difference of priorities. And as a supporter of life, I believe this is the highest priority. When we look at the Constitution, it says our responsibility is to protect life, liberty, and the pursuit of happiness, life being the first and most important. And therefore, I am for this motion.
Thank you. Other members? Chairman Nicholas.
Thank you, Mr. Speaker. On and against the amendment or the motion, ladies and gentlemen. So I've been in here, and this is my 10th year, beginning of my 10th year. Every year, we have between 3 and 6 different bills that address this issue. And we spend inordinate amounts of time over and over and over again, basically redefining, reestablishing, and just kind of putting this thing on the front platter in front of, and taking the time on everything else that we're doing. These bills are always successful as a practical matter, but so what happened this year? Well, 2 of those bills came out and we voted on them and they both passed. And so it's just a matter of balancing of time and effort and focusing on the laws of Wyoming that actually make a difference. And so on and against.
Thank you. Representative Knapp on the motion.
Thank you, Mr. Speaker. On and for the motion. We talked about process, but if this wasn't part of the process, the motion could never have been brought. So let's vote up or down on the motion. Thank you.
Thank you. Other members? Representative Nyman.
Thank you, Mr. Speaker. When I got elected, the issue of life was one of the primary issues that I carried with me as I went around my district, and I presented my willingness to serve in this capacity. And while I respect and admire our leadership, and I have nothing but the most respect for them, you guys have been really good to me. You have gone above and beyond as a freshman to be able to help me understand the process, help me understand how to do this and do it right. And I rely on my majority floor leader greatly, and my speaker and my whip and everyone that's in leadership. Let me just share something with you guys that I have dealt with and tried to kind of come to terms with in when I ran for office and when I came here. I know this is an extremely emotional issue. I understand that. I understand that this takes up many times, and it's been told to me, entirely too much of our time. But folks, let me be completely transparent with you. Every morning in this body, since I have become a member of it, we stand up and we ask God to bless this state, to bless the dealings of this body. We ask Him for wisdom. We ask Him for discernment. We've had multiple pastors from multiple congregations come, and the consent in the concerted belief in every one of them is that we desire that God would order the steps of this state for the blessings of the people that we represent. To me, as a representative of District 1, it is vital that we protect life. That it doesn't matter how much money that we can rake onto a pile. If there are holes in the bottom of our purse, it doesn't matter. While I, with full respect, understand the views of many here in this body that there are maybe other things that are less volatile, I can think of nothing that this body will take care of or have to deal with, which would be more vital than the preservation of life and the recognition of what we keep asking God to do, and that is to bless this house and to bless this state. And if we continue to put this off and call evil good and good evil, then how can we expect that God that we petition every morning to do what we ask Him to do, and that is to bless us in our work otherwise? If this is not one of the, if not the most important issue that this body has and ever will face, that it would have the courage to stand up and say, you know what, Wyoming's going to do what nobody else has done. And we're going to go against the opinion of our court, and we're going to say, you know what, that life is irreplaceable and precious. In my personal opinion, I believe we open the doors for what God can truly do for this state, and we can be a lighthouse to a nation that desperately needs direction. Thank you, Mr. Speaker.
Thank you, Representative Jennings.
Thank you, Mr. Speaker. So for me, I want to turn it a little bit because I don't really want this to be a us against leadership or something of that nature. This is part of the process. And our leadership has told us many times the body rules. Ultimately, the body rules. And this is an issue that we get to vote on. We've gone through 2 reconsiderations and pulled them back and done them, and then they changed those votes. And so I look at this as part of that process. This is what we came down here for. I don't think it needs to be adversarial against our leadership. They've managed our time, and I think that's fair enough. I don't think we need to turn this into an adversarial thing. This is just a thing that our constituents would like us to take up. We need to debate this. We need to take this vote. Hopefully you'll vote yes on the motion. Thank you.
Representative Baker. So members, so let's, and I do appreciate the comments of the last individual that we are on the motion, not on the subject of the bill. So the motion is that what's debatable. So I apologize. I let maybe things go a little bit too far, and the movement started there maybe, but so let's stick with the motion before you, which is on the motion to assign this bill to committee of the whole. Representative Baker on the motion.
Thank you, Mr. Speaker. My comments will be limited to the motion, and I appreciate the distinguishment. Members, I'm just asking for a little bit of situational awareness and just a little bit of recall. If you'll recall, we're given 60 days biannually to meet. The first 10 days of the session were virtual, and we were restricted and limited to just committee bills. So this isn't anything more than an opportunity of the body to express the majority opinion. I think, again, if you just look at the situation, we spent the first 10 days limited to committee bills. That's not historically how that's done. Historically, committee bills generally do take a precedence, but there are individual bills in there. So on and in support of the motion. I hope we don't spend more time debating the motion than we did with the actual bill, but support the motion.
Thank you. Representative Harrelson on the motion, please.
Thank you, Mr. Speaker. I want to definitely see this come forward and come out, but I want to just say that we really appreciate what you guys have done. The juggle you have to do is unbelievable. 400 and some odd bills that got numbered this year, and you got to try bring those out in a way. And so please take this from us, from the body, and from me, that I truly appreciate what you guys have done, but this is an important topic that I believe does need to come forward, especially the topic of this certain bill that is being brought forward. So definitely on and for.
Any other member on the motion? On the motion, Representative Wharf.
Thank you, Mr. Speaker. I do rise in support of the motion. And it's difficult, but I do believe this is not being disrespectful to the process. We all voted to accept the rules. This is a valid rule, and I do believe that we should vote our conscience on this. But I think that we should support this motion. Thank you, Mr. Speaker.
Thank you. Chairman Zwanitzer.
Thank you, Mr. Speaker. Against the motion, but just some clarification, I guess a question. So in my 17 years, we, besides the budget, and that's really what in my belief, the rule is for, in our rules to bring bills directly to the floor. We've never done this, but what we have done historically, I would say maybe once or twice every year, some more, some less, is we have asked and had a motion from the floor to move a bill to a committee, because the institutional process is really what reigns. The Senate on this specific bill, without getting into it, did put some amendments, and I know there are people who would like to comment. And so I looked. This bill has been in possession of the House for 12 calendar days. 10 working days. At any time, a chairman or a member could have made a motion upon belief that it might not be sent to a committee to get it sent to a committee, right? And I know there's some committee chairmen in here who probably would have asked if they'd been asked to make that motion, but it didn't happen. So now we're at the point, it just happens to come today, where even if it got sent to a committee, we're past the 3 o'clock notice requirement that we would have had if it would brought this motion yesterday. And so now it can't get a public hearing. And so I guess I question why we waited till this morning when there was no, the right procedural motion would have been send it to a committee, get a public hearing. That's how the process works. We have now waited till we bypass that part of our process to try to bring it directly to the floor. And we just haven't done that since I've been here. And regardless of the issue, the institutional process that we have for public comments and debate, and that we have allowed things like this that have been in our possession that haven't been sent out in a reasonable amount of time to be sent to a committee. I think that's fair and the will of the body presides, but I don't think it's fair or appropriate to wait till we're past that deadline and then try to bring it directly to the floor. So I'd ask you to vote no on the motion.
Thank you. Representative Sherwood on the amendment.
Thank you,
Excuse me, on the motion.
Thank you, Mr. Speaker. On the motion, I would ask for a no vote. We have precious few hours left to do our work, to do the work of the people. And while I completely understand the desire to have this conversation, I would say we are still in the midst of an economic crisis. There are still some heavy lifts that we have not addressed in terms of the life, liberty, and well-being of our coal miners, of our teachers, of our state employees. And while I know there is a desire and a need to have this holistic conversation, I would say let's keep our eyes on the prize. We still have a list of bills to go through, and let's address this at a later time.
Thank you. Representative Williams.
Thank you, Mr. Speaker. On and in favor of the motion. Yes, we do have we have very few hours that are very precious left. So let's use them to save those who are precious and have no voice.
Thank you. Representative McGuire.
Thank you, Mr. Chairman. In opposition to the motion, and I would just stress again, we're an independent body. And according to Mason's section 111, paragraph 2,
It is irregular and unparliamentary for a member of one house of legislature to quote or refer to the vote by which a measure passed the other house. We're an independent house, and what happens down the hallway has no bearing on what we do, and we have our own internal procedures, and we should respect the process. Thank you, Mr. Chairman.
Thank you. Any other discussion on the motion? On the motion? Any other discussion on the motion? Chief Clerk, members, we're going to vote on the motion. Representative Gray.
Thank you, Mr. Speaker. So a couple things I want to say. For one, I mean, the rules have been kind of loose. Seems like when certain people do something that might not fit something, then it goes up to the mic, and let's just be consistent in calling out when rules are broken. This isn't about individuals, and I think it's really unfortunate that we had that discussion was brought. This isn't about anybody's feelings. This is about life. Okay. I've had bills die at every single part of the process. Okay. And I remember each one. But this is the first time I have done this motion. I'm going to be driving home on Saturday on the Easter weekend, and I'm not going to have through my head that I became a politician just trying to appease people. This is about life. The reason that these bills haven't been brought, this is a big bill, is because every year, at some point in the process, the bill's not allowed to be heard. That's why this hasn't happened yet. And so to say that these are brought every year, this is a big, important bill. And it has not been heard on the floor. I want to talk too about the notion that we've never done this before. It's not true. Just last year, we had a motion to refer something to committee of the whole. Just last year. I mean, I remember it. I looked it up. It was just last year. And in terms of the timing of this, it was meant to be respectful to the leadership because we are on a truncated period. This just came out. We just had crossover last Thursday. It's the crossover day. So I said, okay, we're going to let it play out. Let's see if it gets assigned. That's it. This defines us, this issue, and we should debate it. And I want to say too, this isn't about me personally. I'm not the prime sponsor. I'm proud to be a co-signer on it, but I'm not the prime. So I think that argument was unfortunate. It's not about me personally. It's about our state and the unborn and the voiceless and saving lives. Thank you.
So members, and I apologize to the movement. I was not, I may have said it at some point in the time that I was on second reading rules, but we're just in open debate. This is like committee of the whole on a motion from the floor. So if I made that, if somebody made that assumption, that's why I was just asking anybody else. I wasn't trying to get second times or anything. So we're still on open discussion on the motion to the floor. Chairman Harshman, my apologies to anybody who misunderstood, or I may have misstated that too. Chairman Harshman.
Thank you, Mr. Speaker, and I appreciate the motion, and the motion is a good motion. We're all duly elected. And I just, so I'm not arguing any of that. I'm not, none of that. And I don't have to argue my pro-life credentials with anybody, and neither does the state. And so, hey, the motion is fine, but I'm going to vote against it. And it's not, this bill is trying to fix a problem that right now is not happening. And if it is a big problem, we'll solve it again next year or the next year. We've done some great pro-life stuff already this year. But I don't think anybody really fully appreciates all the stuff that's gone on. There's no playbook for all this. And so I'm not gonna, I just want to assure all of you, this is a good motion. The motion's in order. We're all duly elected. And even if you vote no, that doesn't mean you're not pro-life and you're not going to get your ranking card. That's all in our hearts. A lot of us have stories about this. And so let's don't go there with that deal. And so I respect everybody's vote on this. Regardless of your position, I'm pro-life. I'm going to vote no on this. Don't tell me that I'm not pro-life. Okay, so that's really it. So the motion's in order. I've never seen it done, actually. My 19 years here, pulled out of the speaker's drawer. But the beauty of our system is the majority always rules. And, but anyway, there's a lot going on to managing this thing, and I appreciate the job the good speaker's done. Done this deal with no playbook for the pandemic. It's gone amazingly well, really has. So I appreciate the good speaker and appreciate the motion. I am going to vote no, though. Thank you.
Thank you. Representative Duncan?
Thank you, Mr. Speaker. The previous speaker kind of took a little calming from me. So I appreciate everything he said because I feel 100% wholeheartedly exactly with what he already mentioned. I don't want this in our votes, whether we vote yes or no. I'm voting on a procedural. I'm not voting on whether I'm pro-life or not pro-life. That's not what my vote's about. I also am taking offense of fingers being pointed and directed.
Mr. Speaker, point of order.
What's your point, Representative Gray?
Can we keep this to the motion and not whether it's a pro-life vote or not? I mean, we just got to keep it to the motion.
And I could have probably cautioned you the same way.
Well, let's
So
be.
thank
Thank
you,
you.
Representative Gray. And we will try to keep it to the motion. Thank
Thank
you.
you, Mr. Speaker. Fingers pointing about whether we bring certain bills to this floor and things being in drawers and such like that. I take offense to that. I work really hard to work with my colleagues, to work with the leadership, and to get support and to see that whatever bill I'm bringing is making a difference in the entire state and get support that way. I respect the process. I respect the leadership. There's a lot of things that go on behind the scenes as far as how things work. I'm against the motion.
Thank you. So members, we're just going to stand at ease just for a moment because I'm being advised that maybe something that I was not aware of may apply to this motion. So actually, if the movement or the motion would come up here, we'll just stand at ease for a few moments. So members of the body, let's come back to order. So as we're considering these things, it's been brought to my attention that maybe I misunderstood something, and there's obviously between the movement and I, we're going to have a discussion. And I like the rules committee. So what's in question here is where it's a majority vote of the body to do this, and there's no suspension of rules, or whether it actually requires a suspension of the rules, not 4-7, not that rule, but 6-1, which requires a committee report to be before a bill can be placed on general file. Now, the movement will make his case in front of the Rules Committee. I will we'll take their advice, and then we'll go from there. So the Rules Committee will please join us in front of the dais. All right, members. We're going to come back. We're going to continue with the motion as presented. We're going to continue with the Rules Committee as met. And what we've decided is I made the statement early in the discussion. After the motion, there would be a majority vote. There's enough discussion with the Rules Committee that someone could object to, depending on which way this vote goes, could object to the will of the body, and then it would be and cite another rule, and then we'd have another discussion on that rule and the appropriateness of whether we need to suspend the rules. So we will continue. So members, we are on the motion 4-7 that would refer Senate File 33 to Committee of the Whole on the motion. And again, and to Representative Gray's point of order earlier, I'll remind us all on the motion, not on the issue, if at all possible. Thank you, Representative Gray. Please proceed.
Thank you, Mr. Speaker. And again, as we finish this out, this is not about, do you support person X? Do you support person Y? This is about, are we going to hear this bill in this session? And I think we should. So I urge an aye vote. Thank you.
Representative Ottman on the motion.
Thank you, Mr. Chairman. I just wanted to say, with the amount of interest and debate on this, I think it really needs to be voted on. Thank you.
Thank you. Any other members on the motion? We're not on second rules or second reading, third reading rules. It's just open discussion on the motion. On the motion, seeing none. So members, Chief Clerk, would you please call the roll? And the roll is pursuant to House Rule 4-7, Senate File 133 will be referred to Committee of the Whole. Chief Clerk, please call.
Andrew. Baker. Banks. Bear. Blackburn. Brown. Burkhart. Burt. Clausen. Clifford. Connolly. Crago. Duncan. Eklund. Air. Flitner. Fortner.
Aye.
Gray. Greer. Hallinan. Haroldson. Harshman. Heiner. Henderson. Hunt. Jennings. Kenner. Knapp. Larson Lloyd. Larson Dan. McGuire. Martinez. Nyman. Newsom. Nicholas. Oakley. Obermuller. O'Hearn. Olson. Ottman. Paxton. Provenza. Roscoe. Schwartz. Sherwood. Simpson. Summers. Stith. Stivar. Sweeney. Walters. Washit. Western. Wharf. Williams. Wilson. Winter. Yin. Zawanitzer. Mr. Speaker. Closing vote. Are there any changes? Closing vote. The vote is closed. 23 aye, 37 no.
Thank you, members. So the motion has not been adopted. Mr. Majority Floor Leader. Mr. Majority Floor Leader, with that order of business of bills on third reading consent list.
Mr. Speaker, I move the consent list consisting of the following Senate files: 1983, 117, 136, and 148.
Would any member like any of the bills on consent removed? Any of the bills on consent removed? Any member? I see people moving toward microphones, but nobody's stopping at them. So, reading clerk, would you please read the bills on consent list?
Senate File 19, sponsored by Judiciary. Public Health Emergencies, Immunity Amendments, an act relating to public health and safety being enacted by the legislature of the state of Wyoming. Senate File 83, sponsored by Senator Wassenberger and Education. Gillette College Community College District, an act relating to community college districts being enacted by the legislature of the state of Wyoming. Senate File 117, sponsored by Senator Pappas. Speech and Hearing Specialist Licensing Amendments, an act relating to professions and occupations being enacted by the legislature of the state of Wyoming. Senate File 136, sponsored by Senator Perkins. Required Public Service Commission Considerations, an act relating to public utilities being enacted by the legislature of the state of Wyoming. Senate File 148, sponsored by Senator Rothfuss. Requirements relating to depositors amendments, an act relating to special purpose depository institutions being enacted by the legislature of the state of Wyoming.
Having been read 3 separate times, the question is, shall these bills pass the House? Chief Clerk, please call the roll.
Roll call on the consent list. Andrew. Baker. Banks. Bear. Blackburn. Blackburn. Brown. Burkhart. Burt. Clausen. Clifford. Connolly. Crago. Duncan. Eklund. Air. Flitner. Fortner.
Aye.
Gray. Greer. Hallinan. Haroldson. Harshman. Heiner. Henderson. Hunt. Jennings. Kenner. Knapp. Larson Lloyd. Larson Dan. McGuire. Martinez. Nyman. Newsom. Nicholas. Oakley. Obermuller. O'Hearn. O'Hearn. Olson. Ottman. Paxton. Provenza. Roscoe. Schwartz. Sherwood. Simpson. Summers. Stith. Stivar. Sweeney. Walters. Washit. Western. Wharf. Williams. Wilson. Winter. Yin. Zawanitzer. Mr. Speaker, we have 60 aye. For Senate File 19, are there any changes? Baker, aye to no. Jennings, aye to no. Larson Dan, aye to no. Bear, aye to no. Hallinan, aye to no. Winter, aye to no. Greer, aye to no. Yin, aye to no. Knapp, aye to no. Stivar, aye to no. Western, aye to no. Wharf, aye to no. Clifford, aye to no. Burkhart, aye to no. Ottman, aye to no. Provenza, aye to no. Connolly, aye to no. Burt, aye to no. Nicholas, aye to no. Stith, aye to no. Obermuller, aye to no. Fortner, aye to no. Further changes? Roscoe, aye to no. Further changes? Closing vote. The vote is closed. 38 aye, 22 no. As for Senate File 83, are there any changes? Larson Dan, aye to no. Stivar, aye to no. Banks, aye to no. Jennings, aye to no. Western, aye to no. Baker, aye to no. Duncan, aye to no. Wharf, aye
to no. Gray, I to no. Heiner, I to no. Ottman, I to no. Bert, I to no. Haroldson, I to no. Further changes, Fortner, I to no. Further changes. Closing vote. The vote is closed. 46 aye, 14 no. As for Senate File 117, are there any changes? Are there any changes? Closing vote. Vote is closed. Oh, Fortner, did you want to change? I to no. Fortner, I to no. Further changes? Closing vote. The vote is closed. 59 aye, 1 no. As for Senate File 136, are there any changes? Schwartz, I to no. Yin, I to no. Clifford, I to no. Further changes? Closing vote. The vote is closed. 57 aye, 3 no. And as for Senate File 148, are there any changes? Gray, I to no. Washit, I to no. Nicholas, I to no. Worf, I to no. Flitner, I to no. Greer, I to no. Larson Lloyd, I to no. Haroldson, I to no. Nyman, I to no. Larson Dan, I to no. Bear, I to no. Hallinan, I to no. Knapp, I to no. Winter, I to no. Jennings, I to no. Stivar, I to no. Fortner, I to no. Simpson, I to no. Williams, I to no. Crago, I to no. Duncan, I to no. Duncan, no to I. Okay. Ottman, I to no. Blackburn, I to no. Hunt, I to no. Further changes. Closing vote. The vote is closed. 37 aye, 23 no.
Having received the affirmative vote of the majority of the members elected to the House, Senate Files 19, 83, 117, 136, and 148 have passed the House. Mr. Majority Floor Leader.
Mr. Speaker, I move that the House stand in recess until 2 p.m.
Committee announcements. Chairman Zwanitzer.
Thank you, Mr. Speaker. Committee number 7, corporations will meet in 5 minutes in EO5 to hear Senate File 15, temporary licensing and permitting authority, and Senate File 28, motor vehicle security interest perfection. Additionally, we will meet tomorrow morning at 8 a.m. With a light committee from the Senate to discuss interim topics.
Thank you. Chairman Paxton.
Thank you, Mr. Speaker. Your committee number 4, education, will meet upon 5 minutes after adjournment or afternoon recess to continue Senate File 127, Earn While You Learn, and to consider Senate Joint Resolution 4, School Capital Construction Constitutional Amendment.
Thank you. Chairman Nicholas.
Thank you, Mr. Speaker. Your House Appropriations Committee will meet on adjournment to hear Senate File 122. Your Conference Committee number 1 on House Bill 121 will meet at 1 o'clock in room 301. That's the Capcom room.
Thank you. Vice Chair Larson.
Thank you, Mr. Speaker. Your Select Committee on Tribal Relations will meet in room 6 down in the tunnel in about 5 minutes to have a conversation on interim topics.
Vice Chair Larson, did we assign that committee? Did we assign a committee, conference committee? Okay, Vice Chair Larson, did you have a conference committee time you wanted to announce as well? Maybe it hasn't been assigned.
It's not been assigned, Mr. Chairman. You've had a busy morning, and I think we've got to try to do the concurrence thing and go through all of that
Okay.
motion and assign that. So
All right, my apologies. So
we're-
members,
We're fine.
yeah, my members, these conference committees are supposed to meet and be available for the public. So they need, and they, by rule, they need to be announced on the floor, date, a time and a place for the conference committees. So I'm just trying to keep us on track there because I think we might have let one slide by accidentally. So Chairman Burkhart.
Thank you, Mr. Speaker. House Transportation will meet with its counterpart from the other body tomorrow at noon recess to discuss interim topics.
Thank you. Any other announcements? Any other announcements? Members, we are in recess until 2 p.m. Thank you.